The second case we're hearing this morning is in re Estate of Hermann von Greiff. It is also a 15-minute mini oral argument on the application. That means, Mr. Colman, you may reserve some of your 15 minutes, but we ask you to keep track of that yourself to use on rebuttal. And if you are ready to proceed, you may go ahead.
Thank you, Your Honor. Understood. I would like to reserve 2 minutes for rebuttal today. Thank you. I'm here today to address 3 primary errors committed by the majority in reaching its decision in the von Greiff matter. The majority decision erred in 3 particular ways. Number 1, it impermissibly modified a statute and created an exception for which there are no exceptions. Number 2, it engaged in faulty legal analysis with respect to the underlying claims at issue, the underlying legal issues. And number 3, even if the legal basis was sound and the majority had the ability to take the action that it took, it still created a bad law that harms the very people that the law was enacted to protect and undermines this court's decision in the Irwin matter. Getting back to the first point, the impermissible modification of the statute, of course, stems from our state's constitution. There's a separation of powers, and as this court has noted in many, many decisions, from Inri Mardisian estate very recently to Tarian v. Zwitt, Robertson versus Daimler Chrysler, Van v. Zahorik, just to name a few. It is the job of the legislature to weigh public policy considerations and to create laws. It is not the role of the court to do so, even where the laws enacted by the legislature may lead to illogical outcomes or outcomes that seem absurd to the court. It is simply not the province of the court. It is solely the province of the legislature. And I would note that neither appellee nor the family law section address this issue in their brief because they simply cannot. There is no way to get around that particular problem with their case, and they choose rather to ignore it. That issue alone should lead to peremptory reversal, and I would ask this court to do so and to adopt the dissenting opinion. The dissent, of course, went into great length to outline how exactly the majority abrogated the plain language of the statute by adding a 3rd criterion to the elements of establishing willful absence. Number 1, per the statute, a person for 1 year or more must, number 2, be willfully absent. The majority opinion, of course, adds a 3rd criterion of unless divorce proceedings are pending. And that simply cannot be done under our constitutional scheme. The second point is that the court engaged in faulty analysis. And the faulty analysis in which the court engaged really relies on 5 primary factors. Number 1,
Mr. Colman, let me interrupt you before, because I want to make sure that you get a chance to answer everyone's questions, and then if you have more time, we'll get back to that.
Thank you.
Yeah, absolutely, Justice Viviano.
No questions at this time.
Justice Bernstein.
Hi, Counsel. Good morning. I have some concerns, and maybe you can help me with this. You know, in terms of how we do an analysis, do you feel that the COVID situation, with the fact that you have so many deaths that have happened as a result, and the fact that people have had to be away from each other and aren't able to be kind of in close proximity, how will the renderings of this decision have an impact on, I would imagine, a lot of people as it pertains to some of these issues that are now going to be in play?
Thank you, Justice Bernstein, and a very astute and timely question, given where we are as a society. Of course, the rule established by this court in Irwin is not that you need significant contact. In fact, the test is just some minimal contact, text messaging, phone calls, FaceTimes, anything that we as a society have since grown accustomed to as ways of communication when our personal interactions became more limited due to COVID. All of that would suffice As the dissent noted in the Court of Appeals, we are not looking at to judge whether or not some minimal contact occurred. We're just looking for some contact at all. And so I would say that in that regard, of course, the onus remains on the abandoning spouse to, if they choose not to have abandoned their spouse, engage in some level of communication through some form. We are very lucky in that respect to be a connected society through technology. And so there are opportunities to avoid this outcome, even in these COVID times, shall we say.
Thank you, counsel.
Thank you.
Justice Clement.
Good morning. Just following up on what you just said. So should we take into consideration that parties that are divorcing are often counseled to communicate only through their lawyers, and should that affect our standard for willful absence? Well,
the issue that I think is really at the forefront here is, how do we judge the quality of contacts, the quantity of contacts, and that's something that this court in Irwin very astutely already laid out groundwork for. And this court has already established that these cases should be judged on a factual case-by-case basis and determined by a trier of fact. I do not think it's the role of this court or the Court of Appeals or any other court to create a blanket rule to say where there's direction this way, or in every instance where they're directed to communicate only through counsel, or in every instance where there's a divorce, or in every instance where there's a fill in the blank, that we negate willful absence. I think that those would be issues that would be best judged by a trier of fact, by a trial court, that we entrust a probate court or other trial court to review the facts of individual cases, just as we do in thousands of cases a day pending before these courts, to reach those decisions. And if there is an error, then that's why we have appellate courts. But I don't think that a blanket rule is the best way to address a society as complex as ours, where there are innumerable factual discrepancies that could be at play, and to paint with one brush really does an injustice to the society, our society as a whole. I would analogize this to perhaps somebody who is in military deployment. You may have someone who is deployed during wartime to an active war zone, and for an extended period, facing the harshest of circumstances, he or she is unable to communicate with her spouse. Of course, that would not be willful absence under a case-by-case judged basis. But if you had someone who was deployed during peacetime to a base in, say, San Diego, but has just decided to give up on their marriage and move on, that deployment may not qualify strictly as, that deployment may not negate strictly the willful absence. That's why, again, painting with the broad brush for divorce or for military deployment, these should be judged on a case-by-case basis. And that's exactly what this court established as framework in Irwin.
Okay, thank you for that. And then just following up, this statute appears to me to try to address those situations where an individual is doing, as you said, willfully giving up, or in essence, ending the marriage without legally ending the marriage. That seems to be what the statute is after, is making sure that those spouses don't inherit if a death occurs when that has taken place. But here we have someone that is legally trying to end the marriage. Should we look at that as separate from what is contemplated by the statute?
Well, I don't think that divorce should be judged differently for three different reasons. Number one, I think the plain reading of the statute doesn't provide for that. Number two, I think, as the estate planning and probate counsel pointed out in their amicus brief, a careful review of the legislative history shows that divorce was considered when the statute was enacted, and yet the legislature made no special provision to accommodate for that. And number three, I would again just get back to that this is already a case-by-case situation where people can look to the extenuating circumstances of a divorce. I do not think, as I've briefed, that just by virtue of engaging in a divorce proceeding, that you cannot absent yourself as a spouse. If on my way to Tahiti to run off with a new love interest, I drop some papers off at a court and then never return to Michigan and let that languish there, and a spouse dies tragically 13 months later, that spouse who is being protected is the person who's been left here in Michigan. And have we done that person a disservice by allowing that person who ran off to Tahiti and dropped the papers at the court on his or her way out of the door to get protections and be able to claim a share of that abandoned spouse's estate? I think that's the critical question. I think that what the legislature was really doing was looking towards how do we protect people who have been abandoned? And this ruling by the majority unravels those protections for anyone who's been abandoned but finds themselves engaged in divorce proceedings. Again, a case-by-case analysis of the facts would be the best way to do it, which is what this court has already laid out in Irwin.
Thank you.
Thank you.
Justice Cavanagh.
So just following up, I just want to be clear. I mean, I think you're saying, I hear you were saying that you don't think that there's a blanket rule pertaining to a divorcing spouse supported by the statute, and it's a case by case. So am I correct or would you agree that you're not saying that the fact of a divorce is irrelevant to the determination of whether they've met the standard of willful abandonment? It's just not a per se rule. So the fact of the divorce, including the fact that up until the time of death, say, like in this case, that they are actively communicating through counsel, working out the terms of an agreed upon judgment, that might be relevant to the analysis under Irwin of whether there is sufficient contact or otherwise to establish willful abandonment. So it's relevant, it's just not a per se rule.
I would agree that it's relevant, but not determinative. Regarding the facts of this case, of course, we have a situation where the decedent was very ill. He had no family in Michigan. All of his family was in Florida. He lived in a nursing facility 3 minutes away from the surviving spouse's residence. She made zero effort to visit him, attempt to visit him, contact him otherwise. There's been talk of, I understand, abuse. That simply is unfounded in the record. It is unfounded. There was an argument, the allegation of a verbal onslaught as raised by the majority. When you delve into the record, this was an exhibit introduced by appellee, was characterized as an argument by the decedent. They were a married couple having an argument. I would agree that divorce is a factor to consider, but it should not be the definitive factor.
And just getting back to that point, are you asking us to, or is it really appropriate for us to sort of judge the sort of value of the contact or the morale, the sort of, well, yeah, they were talking about, details about divorce, whether directly or through their attorney, but they weren't talking about things that we think that they probably should have if they were still that. I mean, that's typically not something that we would engage in, right?
I would completely agree, Justice Cavanagh. That is something that would be left to the trier of fact to consider over the course of a hearing. We had a multi-day hearing where the judge in our case, Judge Hill, heard days worth of testimony, umpteen exhibits were introduced. And with the benefit of all of that, she was able to reach a conclusion. I would not suggest that an appellate court should engage in drawing those particular lines. Again, I think that this court already did the best and wisest thing possible, which is to create a case-by-case analysis as it established through the Irwin decision.
Okay, thank you.
Thank you.
Justice Welch.
Yes, thank you. So, counsel, in this case, obviously, the only reason we're here today is because the sort of 1 year measurement for abandonment happened because the court made a mistake. So there was, error in the final order. It was resubmitted to be corrected, and it basically didn't get corrected within 1 year. And that's why we find ourselves here. Should equity play into this at all? Normally, equitable considerations play into divorce actions a lot. I realize we're not talking about the substance of the divorce here, but admittedly, that's a struggle for me because there's lots of reasons courts get delayed. We have courts very backed up right now due to COVID. So there's lots of backups in courts right now, even though cases are moving forward.
I understand. And regarding the facts of this case, there were actual objections, substantive objections to the order, which hadn't been heard. So it wasn't merely a scrivener's error that needed to be corrected. In this case, there were actual substantive objections filed by the decedent that had not been heard at the date of his death. But regarding in general, the equities of delay, we have a statute which prescribes a 1-year time period to review. The courts may not create a common law tolling of a statute enacted by the legislature. This court has ruled that a common law tolling of a statute of a statutory time frame simply is not permissible. And so for that reason, I would say the 1 year has been established by the legislature and it must be respected. I would further note that with respect to the 1 year time frame, there's been some suggestion by the family law section that, and I believe by appellee, that perhaps you could count the period prior to filing of a divorce. So if someone was absent for 2 years, then filed a divorce, that simply doesn't work with respect to the plain language of the statute, because the statute requires that you look at the 1 year preceding death for willful absence. So again, I think that the statute is clear in terms of its language, and I think that this court, through its case-by-case analysis, where a court can take into consideration, a trial court can take into consideration a whole host of factors, is the best way to approach these situations. The majority's blanket rule, however, simply is wrong for a great number of reasons.
So what do we do about the problem that a lot of divorces take longer than a year? I mean, particularly I think of collaborative divorce, which a lot of parties use now, and that frequently takes longer. It's a more thoughtful, longer process. So can everybody now claim abandonment as if somebody were to die in the middle of that process?
Well, if there's zero contact, zero physical contact, zero emotional support offered, then yes, someone could claim willful absence. And then, as established by the legislature and using the framework established by this court in Irwin, a trial court would have to review those facts on a case-by-case basis to determine whether or not, in fact, there was willful absence under the statute.
Okay, thank you.
Thank you.
Counsel, is it possible that there, even if a blanket rule doesn't make sense, that some kind of presumption does? I mean, what do you make of the amicus brief advising us that, especially in cases where somebody is a survivor of domestic violence, that their lawyer is going to tell them not to communicate? I mean, wouldn't a presumption at least make sense in where parties have their lawyers continuing to talk to one another in the middle of a divorce?
I would say, Your Honor, in that regard, that a presumption would not work either. It's simply for this reason, that in a case where there is abuse, that should be a very straightforward matter to defeat a willful absence claim. That is a case-by-case judgment as established by this court under Irwin. There should be no question there. Abuse, and assuming there's abuse, then there are likely personal protection orders. There are likely pleadings to that effect, perhaps police reports. But there should be some factual underpinning to be able to say, no, this was a case of abuse, and for that reason, willful absence does not apply. However, when you create a presumption with respect to divorce, you're really protecting, again, that scoundrel who absconds to Tahiti with his paramour. That's who this really protects, and you're leaving the abandoned spouse without the protections that the legislature wanted to for them. If you're left, you should be able to create a new will that the person cannot elect against. If you die intestate, you should be able to leave your assets to your children and not to the person who's left you high and dry, regardless of whether or not they filed some paper with the court and on their way to the airport. Truly, this court has already established the best possible way to address these scenarios under Irwin.
Thank you. Justice Zahra.
No questions. Thank you.
Okay, we used up all of your time and then some.
I understand.
But
Thank you for the opportunity.
Mr. McDonald.
Thank you, Chief Justice and members of the court. I don't have a lot of things to try and tell you today. I do have a couple, and that is in response to Mr. Colman's argument about the person escaping his marriage by fleeing the country and going to Tahiti and having dropped divorce papers on the way out the door. There seems to be implicit in that argument a fair lack of respect for the court being able to control its own proceedings. Second, I would point out that since 1971, when the act went into effect, or 1972, divorce has been on demand in this state. And to claim that the protection that's afforded by this forfeiture statute is not available to the wronged spouse simply ignores the fact that all that wronged spouse has to do is to take that same advantage, engage in a divorce, and get a fair, equitable property settlement. And that's the conflict that I see between 2801 and the No Fault Act. Once we moved away from fault divorce and moved into divorce by demand, I believe that an irreconcilable conflict was created with this portion of the statute that forfeits a surviving spouse's rights. Because frankly, I cannot tell my client what it was that she did that was wrong. She exercised her right to file for divorce, to try to end her marriage legally. The state controls every aspect of marriage in terms of its termination. You cannot end a marriage in any other way in the state other than by either a divorce or a separate maintenance action. It simply isn't possible. And once you have that situation in front of you, to forfeit someone's rights as a surviving spouse because they have exercised their right to end the marriage legally, I believe is an unintended result by this statute. Now, this is a forfeiture statute. There can't be any.
Mr. McDonald, let me interrupt you because there might be lots of questions. So let me start with this. Yeah, thank you, Justice Viviano.
I have no questions.
Justice Bernstein.
No questions, thank you.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
I just wanted to give you an opportunity to tell us what you think the relevance is of the fact that there is contact between counsel when they're actively pursuing a divorce. I've been looking at the probate court's decision, which seems to recognize that, but for his untimely death, that this would have dissolved in the marriage would have been dissolved in a divorce. They intended to do it, both of them were, they were both going forward with it. They were actively engaging. And yet it seems that seemed to be held against your client, the fact of the divorce. Why is that the case? I mean, why, I guess it's not your argument, but, why is it that shouldn't we be able to consider communication between actively divorcing parties or their counsel as contact sufficient to establish what we said in Irwin?
I believe that that's correct. I believe that should have been considered. If you look at what happened in the divorce, the probate court focused, and I'm not trying to get into all the factual details here because I understand this to be an argument about a particular issue. But in the trial of this matter, the court seemed to focus on an ex parte order that came about at the beginning of this divorce, which I suspect is the case with a high majority of divorces. That order was then modified by stipulation prepared and presented by Hermann von Grieff's counsel that detailed the way that the parties were going to live their lives during the pendency of the divorce. That seems to be a complete non-starter for the probate court. My client agreed to certain things in a stipulated order. The court entered it. It was then followed by the parties. They had a final hearing. They agreed to a property settlement. And those things were all a result of communication that was taking place between counsel for the parties. So yes, I believe that communication is enough to defeat any of these claims that there has been a total abandonment. I come back to the problem of the conflict that I see as inherent between this section of the probate statute and no-fault divorce, and the fact that the state mandates that the only way to end a marriage legally is through the court system. And if the court system cannot deliver within the time prescribed by this statute that forfeits rights, then how are we going to deal with that? Forfeiture is not favored in the law. And to say that someone who is following the prescribed path to end her marriage legally runs the risk of having her rights as a surviving spouse forfeited because she has engaged in that activity mandated by the state, that seems to me to be absurd.
Thank you.
Justice Welch?
Yes, so Mr. McDonald, just what do we do about the problem that there's this, the Court of Appeals has set forth a rule essentially that if a divorce is ongoing, that, the abandonment aspect of the statute won't apply. What do we do with a situation that's been raised by opposing counsel about maybe someone has been completely absent for 2 years and then files for divorce while someone's on their deathbed? How are we supposed to handle that particular issue?
I think, Justice, that if you craft the rule as I've proposed, that problem disappears. In other words, as set forth in, I think, both in my briefing and in the family law section, if you only exempt from the 1 year period a portion of time while a divorce action is pending, then that problem disappears. If someone has abandoned their marriage for 1.5 years, 2 years, and then starts a divorce proceeding, then they still are subject to this forfeiture. If the rule is stated that only the time during the pendency of a divorce action is not to be counted. I'm going to point out again that the way for that wronged spouse to cure the problem is to indulge in a divorce action. And if that wronged spouse wants to keep all of its property and not give any of it up in any fair and equitable division by the court in a divorce action, then there's going to be a risk.
Thank you.
Justice Zahra,
No questions, thank you.
you have some additional time, counsel. You can use it however you like.
I believe I've told you what I want to tell you. Thank you.
Okay, well, thank you both. Mr. Colman, I'm sorry we used up all your rebuttal time and then some, but we appreciate both of your presentations and the case will be submitted.
Thank you.
Thank you.
Thank you.